Work History Form 3369. Welcome. The attorneys at Avar Law Offices would like for you to watch this presentation about the Social Security Work History Form 3369.
What are Social Security forms? Social Security forms are used to determine if claimants are disabled. It is best if the claimants handwrite the forms. That way, imperfections in your writing and your thoughts will come out in the personalized handwritten document, and it will show how your disability affects your ability to do work tasks. If you type the document, that may show you still have some work capacity skills, at least in typing the form. If you have difficulty completing the form, ask your case manager to help you, but state on the form that the case manager had to help you out because of your disabilities.
Why do we use these forms? Social Security uses the Work History Form 3369 to determine if claimants have abilities and capacities to return to the past work you said you did. List only work that was performed in the last 15-year period before the date the disability case is adjudicated or decided. The date of the decision is the date it was decided at each one of the three levels the case goes through. That is the initial level, the reconsideration level, and the hearing level.
What is the DLI date last insured? Remember that if a claimant has a DLI date last insured, the 15-year period runs from before the DLI date and backwards. Ask your case manager what your DLI date is. A DLI date means you must prove you became disabled before that date and that it continued up to the present. DLI date means you ran out of quarters of coverage because you stopped paying FICA taxes into the Social Security system on a certain date because you stopped working. You will be denied if you don't prove disability prior to the DLI date.
What is your RFC? How does Social Security determine your disability based on past relevant work history? They compare your RFC, otherwise known as your residual functional capacity, with the demands of your past work. RFC simply means what your capacity is after suffering your disability conditions. Next, compare this residual functional capacity with the demands of your past relevant work. What is the maximum you can do after becoming disabled? For example, if your past work was very heavy and required lifting, say, 50 pounds, and your capacity after becoming disabled is now 10 pounds of lifting, the adjudicator should now determine that you are disabled from performing your past work because you had lifted more than you could lift now. However, if the past work was very light, say it was lifting less than 5 pounds, and your physical capacity after becoming disabled is for lifting 10 pounds, then there would be no reason why you could not perform your past relevant work. You would, however, generally be not found disabled. Other factors that would have to be looked at are because there are many non-physical impairments that still prevent you from doing the past relevant work. So if you had an unsuccessful carpal tunnel surgery that prevented good skills, such as the use of the hands and fingers, this would prevent you from doing most work, even if they are unskilled jobs. If you had a head injury that affected your memory or a panic attack due to an anxiety disorder, which also affected following instructions and carrying out instructions due to the need to take breaks and the inability to concentrate, that would also prevent you from performing an even unskilled job that you did in the past.
What is a composite job? If a job includes major job duties from several different job titles, it could be a composite job and may not count as past relevant work generally performed. However, it could count as past relevant work actually performed. Judges must determine if you can do past work either as actually performed or as generally performed by the general population. Composite work simply is not past relevant work because it required significant elements of two or more occupations that has no counterpart in the Dictionary of Occupational Titles. The judges uses a book called the Dictionary of Occupational Titles to look up your individual job titles. If one of your jobs included multiple other occupations, it is a composite job. So list all the main duties of the PRW on the work history form. For example, if you listed your job titles as a waitress and described your job duties as a cashier, cook, cleaner, and waitress at a particular restaurant, that would be a composite job and should not count as past relevant work as generally performed.
What is SGA? Your past relevant work, however, has to be met by another definition. It has to be SGA, or substantial and gainful activity. SSA presumes that it is gainful activity if it includes a certain amount of gross wages. For example, in 2020, the amount was $1,260. There are different amounts for each year. For example, in 2015, the gross amount was $1,090. You can Google the SGA tables for each year, which are found at ssa.pomsdi10501.015. However, there are some possible deductions in your presumptuous gross earnings, and these occur when the value of the work was not the same as the value of work in general. Some disabilities require impairment related work expenses called IRWEs. For example, sheltered work includes, for example, working for a family member who created the job just for the claimant in order for the claimant to be eligible for health insurance benefits, and the claimant did not perform work similar to other workers with that same job title. Another example is transportation expenses. If the claimant's disability prevents him or her from driving to work and a third party has to drive the person to and from work, that mileage from that third party can be deducted from the gross wages. The IRS allows approximately 58 cents per mile presently. Another example is a person who is paid for a full time 40 hours a week job but is accommodated and allowed to have a sick day a week or a few days a month. The value of this accommodation will get deducted from gross wages. Another example is the cost of medication if it's paid out of the pocket that is required in order to perform work activity. Proof of the cost from pharmacy bills can be introduced in order to deduct the cost from the gross wages. Your attorneys and case managers have specifically designed employer supervisor work forms that can be used to apply these types of deductions from gross wages. In that way, your past relevant work will not constitute substantial and gainful activity.
What is the SVP level? Another consideration is that past relevant work has to be work that lasted long enough to learn to do it. Social Security uses a book called the Dictionary of Occupational Titles to determine how long it takes to learn a job. The length of time is called the SVP level, called specific vocational preparation. The SVP can be acquired in school, on the job, in an apprenticeship, etc. A 4-year college degree is equivalent to 2 years of an SVP. SVP levels go from 1 to 9. Google ssa.gov.pom's DI 25001.001. The least demanding is an SVP 1 and 2, which are different but both are unskilled jobs. An SVP 1 has, for example, been defined as having a very short on-the-job experience. An SVP 2 is anything beyond short and up to and including 1 month. SVP 3 is 1 month up to including 3 months. SVP 4 is over 3 months up to including 6 months. SVP 5 is over 6 months up to including 1 year. SVP 6 is over 1 year up to and including 2 years. SVP 7 over 2 years and up to and including 4 years. SVP 8 over 4 years up to and including 10 years. SVP 9 over 10 years.
What are MSS forms? Residual functional capacity questionnaires or medical source statements should be completed as soon as after you file your application for benefits. Your case manager will provide you with these forms. They are needed by the adjudicator in order to complete your RFC with the demands of your past relevant work. Ask your treating doctors, PAs, ARNPS, and DOs if they will fill out the RFC MSS form. If they do not do so, the state agency doctors will use their own RFC results, which are not based on meeting with you face to face, but rather they are based on evidence in your written record, generally your medical records and forms that you personally completed for Social Security, including your work history form. Even if you provide that you cannot do past relevant work as actually or even generally performed in the nationwide economy, you still will have to prove that you cannot do other work in the national economy. How this is determined: first, SSA looks at your work history report to see if you have a lot of skills that perhaps could be transferred to other jobs. When filling out your work history form 3369, make sure your job titles correspond to the numbers on page 1 and the subsequent pages. So, if you list number 1 that was employed as a housekeeper, make sure on page 2 that job title number 1 is still the same job as housekeeper. An example of the first page of the work history form is seen on the slide.
The most critical section. This is the most critical section of the work history form, and depending on what you say, may or may not be fatal to your case. When you describe the job in the details section, be careful not to describe things that you are expected to do but never performed. Be extremely careful about how you check off the boxes yes or no regarding the questions. For example, the first question is, did you use machines, tools, or equipment? Don't say yes if you did not do that most of the time. Say no if you did it less than 10% of the time, because a yes answer could mean that you may still have skills that can be transferred to other jobs. Don't say you use technical knowledge or skills if you only use them less than 10% of the time, because again, that could mean you have transferable skills to other jobs. And do not say you wrote and completed reports if you did it less than 10% of the time, since again, it could mean you had transferable skills to other jobs. Even if your work history report does not show evidence of transferable skills, that does not mean you are disabled. That only means there may be unskilled jobs out there that you could perform in the national economy. The national economy does not mean in the city where you live. It could mean Alaska if there are, for example, over 10,000 unskilled jobs in Alaska. In summary, when describing your past work, describe the most demanding parts of your jobs, not only the least demanding. If you had to lift 50 pounds on your past job, your disability today would make it difficult for a judge to find you can do your past job. But if your capacity today is for light work and your past work was light, then a conclusion could be made that you can in fact return to it. Social Security determines if you can do unskilled work by looking at your residual functional capacity, what you can do in spite of your disability, and comparing it to the demands of unskilled work.
The classification of jobs. The least demanding unskilled jobs generally would require the meeting the definition of sedentary work, a sit-down job, which physically requires the following: walking and standing occasionally, defined as 10% of the time, up to one-third of the time, no more than 2 hours, and sitting up to 6 hours. No stooping is required in sedentary jobs, and most unskilled sedentary jobs would require good use of hands and fingers for repetitive hand-finger actions. Sedentary unskilled work does not require lifting more than 10 pounds. Those are typically physical requirements, but not the physical requirements include a capacity for seeing, manipulating with the hands and using the fingers, understanding, remembering, and carrying out simple instruction. Usually, sitting is required frequently or up to 66% of the time. That is not the same as a constant, which is about two-thirds of the time, for 8 hours a day. Also note that many of these jobs allow for a lunch break with a short break in the AM or PM. Jobs are classified in terms of higher excretion demands, sedentary being the lowest, lifting up to 10 pounds, generally sitting 6 hours out of the 8 hour day. Next, light work, lifting up to 20 pounds, generally standing 6 hours out of the 8 hour day. Next, medium work, lifting up to 50 pounds. Next, heavy work, lifting up to 100 pounds. And finally, very heavy work, lifting more than 100 pounds.
Remember to pay and file taxes. When listing your past relevant work on your work history forms, please remember that the IRS requires that you pay taxes on income if you are single and you earn $12,000. If you have not filed taxes, it can be illegal and you can incur either penalties or be prosecuted in cases where it was done intentionally. Note also that the IRS does allow individuals to amend their tax returns generally within the 3 years of the day after they have filed the returns. Therefore, you should make every effort to examine your past relevant work and your tax returns to make sure you are in compliance with the law, and if necessary, file a 1040X form. Be further advised that the IRS can be very lenient and enter into an agreement to accept monthly payments on taxes due.
Questions? I hope you found everything helpful. If you required any additional assistance completing the work history form, do not hesitate to set up an appointment with your case manager to review your forms. In addition, do not send these forms to Social Security, but rather send them to your case manager or attorney for review to be sure they addressed all the issues Social Security requires answers to. Thank you.
Thank you.
Again, this is Jasmine and Jaden, legal assistants at Avard Law Offices. Have a great rest of your day.